Good afternoon, folks. I'm aware of the ATO's practice statements on alternative dispute resolution. Have there been any situations where the ATO has refused to participate in ADR with a taxpayer, even where the taxpayer has requested ADR? And I'm anticipating you'll cite, obviously, taxpayer privacy. So can you give me the exact parameters where the ATO could refuse ADR and still be compliant with its own practice statements?
Senator Small, it's Kirsten Fish, Chief Law Officer. Thank you very much for that question. I don't have that practice statement in front of me, so I would have to go back and revisit it. In terms of your question, though, in general terms, ADR is one of the mechanisms that we have available to engage with taxpayers who are willing to engage with us through that process to resolve their matters amicably and in a way that's satisfactory to both parties. It is something that we are very active in promoting. Our review and dispute resolution area within law design and practice really has a focus on resolving disputes early and preventing disputes by feeding back insights up into the client engagement group when they're doing their work. So our alternative dispute resolution is a real focus of our RDR area. I don't have the terms of the practice statement in front of me, but we really are focused on ensuring that taxpayers who are engaged with us, we will engage with to resolve the matters as amicably as we can.
And I might say, Senator, that not every case is necessarily suitable for ADR.
So, Commissioner, that's exactly what I'm asking for, is for you to articulate where those circumstances apply.
Okay, well,
so if you can give me absolute clarity,
not...
Commissioner, if you can give me absolute clarity on where ADR would not be appropriate, that would be very helpful.
Well, one example is where there is entrenched evasion or obstruction of tax investigations and, complex, long-standing, difficult situations with people that dispute everything and don't pay tax when it's due and take legal proceedings against every point. There's not much point going through an ADR. So if you have a particular taxpayer that you are making representations on, we would again be happy or glad to hear that and to provide back to you our view, if we did not do ADR, why that was. But typically it's the high end of evasion, it's the obstruction of investigations and highly litigious at every point. So why would you do an ADR with someone like that?
Indeed. And so I guess just for absolute clarity then, where you form a view about a particular taxpayer, what you're effectively saying to me is that then would preclude ADR from being pursued by that taxpayer. Because, I mean, that's effectively what your evidence just then reflects to me.
No. If that view is formed over a 10-year plus period of consistent evasion, avoidance, obstruction and legal points all the time, we have ADR for all sorts of people that may be a bit confused or a bit uncertain. If you've got entrenched avoiders, ADR won't help.
And so where a taxpayer,
if you're willing to provide the taxpayer that you're...
So where a taxpayer in that particular circumstance approached the ATO with a view to engaging in good faith ADR to de-escalate for both parties, are you saying that would not be appropriate?
No, I'm not saying that at all, but I'm saying the history of matters, the attitude of taxpayers and the history of non-payment and non-compliance will go to whether an ADR facility is appropriate or worthwhile, or whether a more legalistic, which is generally the way they tend to go, will be more appropriate. But if you want to provide the details to the taxpayer, we'll certainly have a look at that.
Okay,
And
thank you.
Kirsten may wish to add to that.
No, thank you, Commissioner. That's very helpful. Can I ask, with respect to the matters before the High Court, effectively, I just need to understand the policy implications of the case, of course referring to Commissioner of Taxation versus Carter. Because trusts, discretionary trusts, are used by so many people in Australia, small business people, family businesses, farmers, you name it. I asked some questions last estimates, and frankly the answers didn't really give me a lot of clarity around what the effect would be. So is the effect of success at the High Court for the ATO such that a distribution made to an unknowing and non-consenting beneficiary, not disclaimable post June 30, notwithstanding that that particular beneficiary didn't receive any actual money?
Senator Small, I know that you raised these questions last time. As I talked about last time we met, the issue in the High Court is not about the legal effectiveness of the disclaimer. The issue in the High Court is about the tax consequences of a legally valid disclaimer. What the Commissioner is seeking through the High Court proceedings is clarity and certainty about how the tax law operates in those circumstances. We see late disclaimers of trust entitlements are increasingly prevalent in high wealth family groups. This represents a risk to the Commissioner recovering tax that is properly payable, where disclaimers happen very late after review periods are finished. Bringing this case will provide certainty and clarity both for the community and for the Commissioner as to how the tax law operates when there is a legally valid disclaimer.
Right, and I also asked some questions around that exact point whether consultation with Treasury, etc. occurred, because I guess my question is, could we have achieved an equivalent outcome for the ATO without going to the High Court on a particular matter and in fact sought to legislate for certainty for all Australian taxpayers?
Senator, a change to the law or a change to policy really is a question for Treasury. What we do from the tax officer's perspective is interpret and apply the law and seek clarity from the courts where we need that clarity as to how the current law operates.
But that's a bit inconsistent with, we're seeing that this is a risk to tax revenue, that they're not necessarily consistent statements, if I could put that to you.
Well, Senator, whether or not the law is changed is a matter for Treasury. Whether it requires to be changed depends on the current interpretation of the law as it exists, and that is what we're testing in these proceedings.
Okay, thank you.
Also, what we need to ensure is that income derived through business activities, whether it passed through one or multiple trusts, ultimately should be taxed at either the trustee or the beneficiary. Right? It's profit. And in opposing many trusts, disclaiming present entitlement, all sorts of things happen to try to divert us from our attention to ensure that everyone, for the benefit of the community, pays the right amount of tax. And again, if you would like to name the people either now or privately that you're concerned about, we will take that on board.
Yeah, and look, I guess the point on this, Commissioner, is it's actually not about a particular taxpayer, it's about the tax implications for literally millions of Australians that use this. Because if I set up a discretionary trust and make a distribution to you that you don't know about, and I'm talking about you in your personal capacity here. If I make a distribution to you for tax purposes and you can't disclaim that post-30 when you discover it, notwithstanding that you haven't received any money, I would suggest that poses a very serious problem in our tax system.
That's not the facts of the case you're talking about.
So, Ms Fish, can I guess, on notice, I would really like to fully understand, and if you don't want to do it on notice, want to give me a briefing, I'm happy with that. But I guess what I am gravely concerned about is the implications of success in this case for every user of a discretionary discretionary trust structure within the Australian tax landscape.
Yep. So
Well, I'm
Senator-
disinclined to take it on notice because it relates to one case that's in the judiciary system, and let that run.
But millions of taxpayers use discretionary trusts, as you would know better
And they
than I,
don't
Commissioner.
disclaim their entitlements in the way that has been done.
So
in this
Chief
way.
Law Officer just said that it is increasingly used within the tax system. So I'm getting very conflicting pictures here.
So
There are many family trusts that run many businesses, farms, everything. And they work as natural and as they're supposed to do. The trustee distributes the money, the beneficiary puts it in their account. It's extraordinarily unusual for a beneficiary to get money from someone that they didn't know about. Would you do that? Would
We're
you
talking
give money
about
to someone
the
you don't know
distribution
about?
of a
No,
tax.
you wouldn't. I wouldn't
Sorry.
either, right? So
Yeah.
it's a very, very unusual situation. It's before the court, and let's leave it at that. And we can do something with you separately, but we're not going to take it on notice.
Thank you very much, Chair.
Okay, thank you very